Mr. Kannabiran, these Naxalites who want to overthrow the government, overthrow the constitution and all that. Why should say they seek protection under the constitution? Then I told them, sir, when such values come before this court, it is not their values which are on trial, but your values. Your values are in trial. Your constitution is on trial. You write in the
That's the
constitution.
lawyer Kandala Gopalaswamy Kannabiran, or KG Kannabiran, speaking in the film The Advocate, a documentary about his life by the filmmaker Deepa Dhanraj. Kannabiran passed away in 2010 at the age of 81, after a lifetime spent fighting for human rights and against state impunity. Some called him a Naxalite lawyer, as he became the movement's go-to advocate in Andhra Pradesh in the turbulent 1970s. But, as he says in that clip, his fight wasn't for the values of the Naxalites. It was for the values of our constitution. Kannabiran's mission was to ensure that all Indians were protected by the constitution, even those who denounced it and the Indian state. For over 50 years, Kannabiran was in the forefront of India's civil liberties movement. He argued cases for hundreds of poor and disadvantaged prisoners, including some on death row. During the emergency, he fought for political detainees. He exposed so-called encounter killings. He was a leading voice on labor and working class rights, and all through, Kannabiran was resolute in his belief that constitutional protections and freedoms had to be enjoyed by everybody. Here is his daughter, Kalpana Kannabiran, a lawyer, activist and academic, telling us about how her father described his own work.
His description of himself for a very long time has always been Sisyphus, because he believed that he was doing work and kept doing and redoing the same work. It was Sisyphean labor that was unceasing. And this was his imagination of his work.
Sisyphus is a character in Greek mythology who was condemned by the gods to roll a boulder up a hill each day, only for it to roll back down each night. So much of what KG Kannabiran did resonates today as governments imprison their critics, pass new repressive laws, vilify civil society, and throttle fundamental rights. By delving into some of the episodes of his career and his approach to the law, we're hoping to illuminate what it means to fight the good fight for the Constitution, day in and day out. Welcome to Season 3 of Friend of the Court. I'm your host, Raghu Karnad. India became a republic on 26th of January 1950, and its constitution marked a new social contract between the people and the state. This contract pledged to uphold citizens' freedoms, but also to secure them social and economic justice. In the early decades of independence, especially, the state struggled to keep this promise. In many parts of the country, landlords held on to their traditional power, including over the lives and the bodies of those who worked on their land. In the 1960s, peasants and tribal sharecroppers began taking up arms. They rejected the constitution as an instrument of the bourgeoisie. This came to be known as the Naxalite movement. In the mainstream imagination, the word Naxalite conjures up the image of a domestic terrorist. The word comes from a place called Naxalbari, a village near Darjeeling. The movement there was led by the communist leader Charu Majumdar, who believed that violence was necessary to break the patterns of age-old feudal exploitation. Many peasants in the region answered his call, and they gathered weapons and fought their landlords and the police. The movement grew, and it attracted young people, college professors, and working-class volunteers from all over the country. They all wanted to fight for the swift end of class inequality. The movement spread further and faster than anyone anticipated. In the late 1960s, it swept the tribal areas of northern Andhra Pradesh, terrorizing police and landlords. Naxalites there killed nearly 300 people over the following years. In response, the state government launched an aggressive, colonial-style crackdown. It used a 1948 law to declare the entire tribal belt in northern Andhra a disturbed area. This gave the police special powers in these areas. They could make arbitrary arrests or even shoot and kill anyone they believed was a threat to public order. Soon, news of encounter killings and custodial deaths was coming out of these districts. Within a few years, thousands had been arrested as Naxalites. The rule of law seemed to have become an alien concept. The police saw Naxalites as seditious rebels who didn't deserve fair trials or the right to life guaranteed by the Constitution. A group of activists and lawyers were determined to bring the government to account. In 1969, they organized a meeting in Hyderabad to chalk out a legal defense strategy for activists accused of being Naxalites. Around 40 lawyers attended that meeting. One of them was KG Kannabiran.
There was no civil liberties organization. There is no organization worth the name which could raise its voice against this kind of atrocities. Then my friend Ravi Subbarao, who was in the CPI, he was very much interested in defending these cases. And in fact, he roped me in, actually. He was the person who said, you must come and help us. So I agreed. And then we met at Hotel Haridwar in Sultan Bazar.
That's Kannabiran, in another clip from the documentary The Advocate. Kannabiran showed up at the hotel, a fading blue and white building in the heart of Hyderabad. By this time, Kannabiran had established a flourishing law practice, but a life in law hadn't always been on the cards. He was born in Madurai in 1929. Later, he took a master's degree in economics at Madras University and sat for the civil services exams before finally choosing to study law. His daughter, Kalpana Kannabiran, is a lawyer, activist, and academic whose work explores the intersections of sociology, law, human rights, and gender. And she's also translated and edited The Speaking Constitution, a collection of her father's writings.
And in his days, it was law or the civil services. There weren't too many options. So law was an option which he took. I wouldn't say that he was ever uninterested in it, because he was interested in questions of justice or fairness.
According to Kalpana, her father's interests in these questions was piqued by a cousin who was a communist.
There were many people from both sides of the family who were engaged in, particularly in the communist movement. And so he did have a background in movements and had a background on, observing issues playing out. His oldest brother was a member of the Communist Party. He later went...
Kannabiran enrolled in the Madras High Court in 1954. In the early years of his practice, he was mentored by another cousin, a successful lawyer there.
A cousin who was a lawyer who was supporting him. So he decided to do law rather than take up a job as a clerk or something after a BA or a BA honors.
In 1960, Kannabiran, by now married, decided to move to Hyderabad and start his own practice. He took on a mix of criminal and civil cases, political cases, and service matters. He later wrote that he never sought out work and simply took whichever case came to him. He became a lawyer for Parry & Company, a leading sugar firm, and dealt with several company matters. While he continued to follow debates in the Communist Party, there was nothing overtly political about his work, until that meeting in the Hotel Haridwar. That evening, at the fading blue and white building in the heart of Hyderabad, he was appointed the convener of the newly formed Naxalite Prisoners Defense Committee.
Actually, around 69-70, when Karnad started getting all these cases of defense and of political prisoners, my whole life changed.
That's Kannabiran's wife, Vasant, a college professor, also in an interview from The Advocate.
Till then, it was a nice, comfortable, middle-class life. Children, husband, job, school, whatever. But when this started happening, there was a qualitative change about life. From a nice, middle-class, cocoon-like existence, we were suddenly becoming a part of history.
The lawyers in the defense committee distributed the cases amongst themselves. They had their differences with the Naxalites, but they all agreed on one thing. The state was using excessive power to crush the movement. This wasn't a particularly popular view. Kalpana explains.
I think there were not too many lawyers who were willing to take up the cause of, defending personal liberties of political dissidents, because we had inherited, at the time of independence, we inherited an animus towards communism, particularly in the state of Andhra Pradesh. And so it was quite to be expected that there wasn't a really large group of people, or a generalized sympathy towards communist detainees.
By rejecting the constitution and taking up arms, the Naxalites threatened the legitimacy of the Indian state. The Andhra police responded by suppressing the movement. For Kannabiran, their response was reminiscent of the colonial state. Instead of addressing the problems that provoked the uprising, the state resorted to killing and detaining its own citizens. Holding the police to account was never going to be easy. The Naxalite side of the story rarely ever made it into the media. They were arrested or killed before they could speak. Police and the media painted them as the worst kind of criminals. The challenge before Kannabiran and his colleagues was to make the court see Naxalites in a different light, and he had a novel approach. He didn't just defend his clients against the state, he turned the courtroom into a stage for dialogue about the idea of citizenship under the Constitution.
And he was one of the people who was engaged in the dialogues even within the profession and willing to take up the cases that came before him. From that time till the time that he died, his single-minded focus was on personal liberty.
After the Hotel Haridwar meeting, Kannabiran filed about 250 petitions to challenge the arbitrary arrests of Naxalites under preventive detention laws. Among the detainees were 3 revolutionary writers and poets, Nikhileshwar, Jwalamukhi, and Cherabanda Raju. The government had booked them for inciting violence against the state. Their case came to be known as the Digambara Poets case, as the group called themselves Digambara Kavalu, or naked poets.
So we as a poets, young poets, as we believed in radical change, we thought the mere writing poetry, but it should be active as such, and the poets' writing should be associated with the movement also, people's movement also.
This is the Telugu poet and Sahitya Academy Award winner K. Yadav Reddy, better known by his pen name Nikhileshwar. As he says, Telugu poets, writers, and artists of the 1970s believed that art had a role to play in the progressive transformation of society. Nikhileshwar and others founded the Revolutionary Writers Association, also known as Veerasam, in 1970. They soon became an influential force in the world of Telugu literary criticism.
Veerasam released a book, Janja, a poetry anthology. Janja released it. That became so popular that within 2-3 months, it went into 3-4 editions. And then governments was scared. The government thought that it is going to be a wildfire among the youth. So they banned that book. So as such, in an assembly itself, Home Minister Vengal Rao, he termed us as a verbal Naxalites. As now they are called, what do you call it now? Urban Naxalites. So in 1970 itself, in assembly itself, he termed us as a verbal Naxalites. And he said that they are more dangerous than the real Naxalites.
The 86-year-old, with a shock of white hair and spectacles, met us at his home in Hyderabad, where he remains active in the literary scene. In 1971, this genial, soft-spoken gentleman was arrested for inciting violence through his words.
3 of us were arrested under Preventive Detention Act. We were charged with various charges, that is particularly 124A, sedition charge. That is writing against to overthrow the well-established government, whatever they said you should. So we were put into jail.
The government said that the poets were a threat to the state and wanted to wage war against it. Such crimes constitute offences against the state, and they attract the strictest punishments, life imprisonment or the death penalty. Unlike crimes like murder or theft, offences against the state are vaguely defined, leaving room for the police to apply the law arbitrarily. For instance, sedition is defined as inciting hatred or contempt against the government through words or actions. The police could apply this to anything from criticism of the ruling party to plotting to destabilize the government. When Kannabiran caught wind of the poets' arrests, he offered to defend them. P. Venkateshwaralu, another lawyer, joined him.
Mr. Venkateshwaralu and Kannabiran, they took the case. They came forward voluntarily without charging any fees or anything at all. Because they thought that our movement was a real movement, people's movement. So they came forward, took the case, and then the process went on.
Kannabiran and Venkateshwaralu filed a writ petition asking for the arrested poets to be produced in court. They also questioned the validity of Andhra's 1970 Preventive Detention Act. This law said that a court could not dismiss a detention order simply because the charges it made out were vague or irrelevant. Kannabiran and Venkateshwaralu said this was unfair and unreasonable. One morning, when the 3 poets were produced before a packed courtroom, Kannabiran had a wily piece of courtcraft up his sleeve. He asked the poets to recite their work in the courtroom and urged the judges to decide for themselves whether they were seditious or not.
Bhayam చావులాంటిది వచ్చే ఉపద్రవాన్ని ఊరించి ఊరించి నరాలలో నీరు పారిస్తుంది. This is the Telugu original poem. మరీ అంతగా చావుకు భయపడి పశువు కంటే హీనంగా. The essence is bhayam means fear. So to overcome the fear, in that particular poem, I expressed my idea of fear, saying that live a life of full strength without fearing the establishment.
Kannabiran's idea was to demonstrate the actual nature of the poems and the absurdity of the charges against the writers. And it worked.
So obviously, after reading our poems, the judges felt that there was nothing wrong in that poems. That was seditious. Then we were released, of course.
In their judgment, Justices Chinnappa Reddy and A.D.V. Reddy noted that, quote, nobody can be detained for possessing opinions and expressing them. Not only were the poets released, but the judges also reviewed the Andhra Pradesh Preventive Detention Act. The bench struck down the provision which said that a court could not examine the grounds for arrest. Then, in 1973, the High Court once again set aside the preventive detention orders of other poets and writers. But these court pronouncements did little, actually, to deter the government. In fact, it took things to the next level.
The High Court was setting aside the preventive detention orders. It was striking down the laws.
This is the poet and activist Varavara Rao, speaking in Deepa Dhanraj's documentary. Today, we know him as one of the accused detained by the police in 2018 in connection to the Bhima Koregaon case. Rao was finally released on bail in 2022 after spending 4 years in jail without trial. But this wasn't the first time he experienced something like this. Back in the 1970s, he was a member of the literary association Virasam, and he was detained by the Andhra police for inciting violence through his writings. Kannabiran came to his rescue and got him released. But as Rao says in this clip from the documentary, the government was in no mood to give up.
It happened twice, so it was portrayed as though there was an immediate connection between their writings and what was going on.
Rao is referring to what came to be known as conspiracy cases that the government pursued against the Naxalites. 22 such cases were filed between the 1960s and the 1990s, and Rao was himself charged in some of them. Kannabiran argued in 6 of them, and a large part of his legacy lies in how he dealt with these cases. Conspiracy cases were a tried and tested method of the British to delegitimize communist movements in India before independence. In the 1970s, the Andhra Pradesh government took a leaf out of that playbook to weaken the Naxalite movement. Hundreds of Naxalites were booked for various crimes, such as dacoity, murder, conspiracy to wage war, and sedition in police stations across Andhra. The police would then link all these cases together, describing them as a unified plot against the state. Then the police accused revolutionary writers, poets, and other activists of being party to this conspiracy, even if they had committed no crime themselves. Kalpana tells us more.
But there were too many cases in which people who were implicated in one conspiracy case were also implicated in another, and where it was not a single crime. So there was a pooling of crimes, each of which had its own trial process and process of conviction and so on.
The charge sheets in these cases emphasized the Naxalites' rejection of the constitution and their communist beliefs. There was no rigorous investigation or evidence gathering. The cases hinged on public meetings of the Naxalites, which were attended by hundreds of activists, writers, and others. The police drew up a list of such meetings and linked them with the offences. Kannabiran's guile and talent lay in unpacking the police charge sheets bit by bit. He picked on factual and procedural inconsistencies to cast doubts on the credibility of the charges. Some of these cases, like the Secunderabad conspiracy case, would drag on for 15 years. The hearings were disrupted by frequent changes on the bench. Many of the accused stayed in prison for years as the trial went on. The real punishment wasn't the sentence. It was the long, drawn-out process. Trials caused tremendous stress and difficulty for them and their families. Everyone knew that a conviction was a long shot, but the state used these cases to harass dissidents and put them through the legal ringer. In the end, the accused were never found guilty of conspiracy. Kalpana Kannabiran tells us more.
And in the Naxalite conspiracy cases, all of them led to acquittals. The majority of people were acquitted. Some were convicted of minor crimes, not for conspiracy, but either under the Arms Act or other minor offenses, and for reduced sentences, but very few like that. Almost all were acquitted. So the charge of conspiracy was not made out in what are touted as the major conspiracy case. And there were huge holes in the argument of the police at different points, right from the procurement of arms to the carrying out of offences, to the location of offences, to the pooling of different crimes into a single case.
KG Kannabiran spent 30 years of his career defending accused Naxalites in conspiracy cases. During this time, his stature as a civil liberties leader grew. In 1974, he became a founding member of the Andhra Pradesh Civil Liberties Committee, or APCLC. This committee served as a watchdog of state violence in Andhra, and it called out suspicious encounter killings and disappearances. All through, the Naxalite movement endured in pockets across the state, and so did government retaliation. In fact, in the mid-1970s, the conflict was only getting worse.
भाइयों और बहनों, राष्ट्रपति जी ने आपातकाल की घोषणा की है। इससे आतंकित होने का कोई कारण नहीं है। आप सभी
Indira Gandhi declared the emergency on the night of 25th June, 1975. The government suspended fundamental rights and threw thousands of opposition leaders in jail. Kannabiran became an even busier man during the emergency. His phone often rang through the night. news of his friends or associates being arrested, and people calling to ask him to take up their cases. The illegal arrests and detentions of Naxalites, student leaders, and activists spiraled. Kannabiran later wrote that he was being surveilled and sensed that the government could arrest him too. Still, the environment of fear and suspicion didn't stop him from representing detainees.
No, it's just that he never refused a case. It was as simple as that. He never said, I'm not going to appear for you. There was a way in which he approached his work that conveyed to people that they can take the liberty of saying that he is representing them. And in the same prison, in the same jails, there were also people who he was representing. So if there was an unrepresented detainee in jail and it wasn't easy to get hold of a lawyer, he was just told as he was going out by his fellow detainees, just say, he's your lawyer and he will come and argue for you.
On June 27th, Kannabiran filed a writ petition against the detention of P. Venkateshwaralu, his colleague and secretary of the APCLC. The police had raided Venkateshwaralu's house and confiscated his books and APCLC documents. In court, Kannabiran challenged this arrest and the validity of the Preventive Detention Law, MISA, or the Maintenance of Internal Security Act. He also questioned the legality of the emergency itself. Kannabiran told the court that there were simply no grounds for his client to have been arrested. Here's Kannabiran recalling the case in the documentary The Advocate.
Because it was at the admission stage, initial stages of the hearing. And if they have grounds, direct the public prosecutor to produce the order and the grounds. Then the public prosecutor foolishly got up and said, the grounds are being typed. I said, the court may record the statement of the public prosecutor and release Mr. Venkatesh. Because grounds are not in existence when he was arrested and it's being typed now. So he is entitled to release.
The court didn't accept Kannabiran's position, but it's a classic anecdote that pops up frequently in mentions of him. In a single spontaneous exchange, he exposed the intent of the state, the ridiculousness of first arresting someone and providing reasons for it only later. Even as this case was being heard, hundreds of other people were being arrested and detained across Andhra Pradesh. Kannabiran ended up filing more than 200 petitions in those years. His daughter, Kalpana, was in high school then and watched her father hard at work. She tells us more.
And it was incessant. It was like, morning, noon, and night. There were always cases to be argued. He was always required to be in multiple courts at the same time. Among those people who were detained, there were several who also argued their own cases. So it was, one has to actually, I think, imagine him in that court in the midst of a significantly large set of people who were resisting the emergency. And the court was that space of theater and performance of resistance against the emergency. And the constitution itself then acquires a very, very different quality. So he is reading the Communist Manifesto to the judge. He is quoting William Shirer to the judge. He is quoting revolutionary poets in Telugu. And then, they're all coming out of court and addressing people and telling not just the press, but also telling people what the case was about, what transpired in court, and what their arguments were. So it was a huge exercise in public education.
Meanwhile, reports of Naxalites and activists being killed in police firing kept emerging from across Andhra Pradesh. After the emergency was lifted in 1977, Kannabiran and other civil rights activists were determined to investigate its gruesome state violence.
Of course, encounter deaths, which has been like his lifetime work, labor of love that he calls, which has been to make the state responsible for the acts of murder committed by the men in uniform. And I think just to drive home the point that an encounter death is nothing other than a homicide. I am Nagasaila. I am an advocate practicing at the Madras High Court. And of course, I'm also an active member of PUCL here in Tamil Nadu.
PUCL, the People's Union for Civil Liberties, a body that Kannabiran led for 2 decades. D. Nagasaila worked with Kannabiran on several major cases.
But when you start using terms like, euphemistic terms like encounter deaths, you are some kind whitewashing it and legalizing it. And it is that rendering of legitimacy, that veil of legitimacy which the state was trying to give an act of murder. His entire life a good part of his life was spent in trying to pierce through that veil and show it for what it was, which is a murder.
In April of 1977, the Janata government led by Morarji Desai appointed a committee to investigate encounter killings in Andhra Pradesh. The committee was headed by former Bombay High Court Judge V.M. Tarkunde, and Kannabiran was one of its 8 members. On the whole, the committee examined 77 alleged encounter killings. Kannabiran and others crisscrossed the state, speaking to people, collecting evidence, and picking apart the police narratives bit by bit. The committee published an explosive report. Its title was Encounters Are Murders. For the first time, supposedly spontaneous encounters with Naxalites were exposed as well-planned murders by the police. The report named specific police officers and called for a more detailed judicial inquiry. Under pressure, in August of 1977, the central government set up a one-man commission under Justice Vashishta Bhargava, a retired judge of the Supreme Court. This commission had to investigate 300 encounter killings in Andhra Pradesh. Kannabiran appeared before it and laid out the Tarkunde Committee's findings. But the commission was wound up in just a few months because of witness intimidation and political interference. Kalpana Kannabiran told us that the Tarkunde Committee report still managed to spark a statewide conversation about state violence and police power.
Although the Bhargav Commission itself was folded up and not allowed to continue till the stage of its final report, I think that entire public discussion, if you look at the newspapers, for instance, of 1977-78, you'll find a stunning coverage on police encounters. So nobody anymore treated encounters as armed encounters between armed criminals and the police. You began to treat encounters as shoot at sight on unarmed people. I mean, that the whole meaning of encounters changed as a result of the work of civil libertarians in that period between 76 and 80 or so.
The public response to the expose energized Kannabiran and his fellow activists to organize more investigations or independent fact-finding missions. These have long been an important tool to fight state abuse and oppression. In 1978, Kannabiran was elected president of the APCLC, and under his leadership, the committee committed itself to independent fact-finding. These investigations were a form of constitutional labor. They contributed to upholding rights. In Deepa Dhanraj's documentary, Kannabiran spoke about what he hoped to achieve.
Tarkunde committee really was appointed to us that we should constitute this kind of fact-finding committees and go on releasing the information to the people. More to educate the people about this than to reach across to the government, because we knew that the government is absolutely impervious, indifferent to this kind of killings.
In the 1983 state election, police violence became a campaign issue for the first time. The Telugu film star and newly minted politician N.T. Ramarao, or NTR, promised a government that would keep the police in check. His party, the Telugu Desam Party, promised to abide by democratic principles and traditions. But NTR abandoned his promise soon after he won. Within the first year of his term, the Andhra Pradesh Civil Liberties Committee, or APCLC, itself became a target of police repression. Its members were booked for obstructing police on duty, and printing presses were ordered to stop printing the committee's pamphlets. As we heard earlier, Kannabiran often referred to his work as Sisyphean, meaning that progress and change were elusive despite his constant efforts. This was especially true of his fight against encounter killings. No matter how many exposés the APCLC and other organizations carried out, police brutality never seemed to end. But when one chapter of the struggle ended in a fact-finding report, the next one began, in the courtroom. Sometimes, the fight got personal, as in the case of a man named Madhusudan Raj Yadav. Almost 20 years after the Tarkunde Committee report, Kannabiran read in a local paper that a Naxalite had been shot and killed in an alleged encounter in Hyderabad. The person wasn't named in the papers, but Kannabiran heard that this might be Madhusudan Raj Yadav. Yadav had helped Kannabiran in the past, during the Tarkunde Committee's investigation, and Kannabiran had become friends with the young man. He'd even attended his wedding. Now it looked like Yadav had become a victim himself. The next day, Kannabiran walked into the courtroom of the Chief Justice of the Andhra Pradesh High Court and made an oral application himself. The case was eventually filed as KG Kannabiran versus Chief Secretary of Andhra Pradesh.
There was an encounter which had taken place. There was somebody called Yadav who was killed, and nobody was wanting to appear to file a PIL against him. So it was at that point in time that Kannabiran came forward to become the petitioner.
This is V. Suresh, a lawyer and the National General Secretary of the PUCL, the People's Union for Civil Liberties. Kannabiran pointed out that this death was suspicious, and the court should ensure, first of all, that the police did not dispose of the body to cover up evidence. The two-judge bench passed an interim order directing this. 2 weeks later, Chief Justice P.S. Mishra and Justice C.V.N. Shastri passed a judgment. They pulled up the state police for failing to investigate the suspicious death. And crucially, they took the matter out of the police's hands and directed the Central Bureau of Investigation, the CBI, to investigate.
And then the case went on, and he gave a judgment saying that encounter is a homicide. It has to be investigated, and on investigation, the person who committed the murder must be prosecuted. After so many years of toiling, in 1997, I got this judgment.
Kannabiran saw this judgment as a personal victory, and a victory for the civil liberties movement as a whole. He had been fighting to hold police accountable for encounter killings for almost 25 years. And this was the first time that a judge had ruled so strongly on the issue.
Now, the point to be noted in that case, for 25 long years, he'd been waging a battle on this legal principle that encounters is nothing else but homicide, done by people in uniform. For 25 long years, and hundreds of cases which had been dismissed, he kept on and on and on and on. He never gave up hope that someday the principle will be accepted. And until eventually, in this particular case, it was accepted by the then Chief Justice of the Andhra Pradesh High Court.
Those who saw Kannabiran at work said he approached his cases with one eye on the details and the other on the bigger picture. One aspect was to present a case by telling a story to draw the judges in. Suresh tells us more about Kannabiran's style in court.
He taught us a lot of courtcraft. There are two parts to the courtcraft he taught us. One are the jurisprudential principles. Okay. The second thing are the court practices. Like he would tell us, think of the court as a classroom and think of a judge as somebody whom you're training, and be thorough with the law. So you take a class in the court. And you may not believe it, but ever since then, now for 35 years now, I am quite famous in the court for starting out with the bird's eye view, and I start a storytelling session. Stories are the best way to reach out to judges.
As Suresh says, Kannabiran wasn't afraid to challenge judges or to appeal to them with unconventional techniques. His method also created empathy for Naxalites and others who were often described as the worst kind of criminals. In a story that has entered legal folklore, he once sparred with Justice Madhusudan Rao of the Andhra High Court in a Naxalite case. Let's hear about that from Suresh.
And when the senior judge told him, Mr. Kannabiran, you are arguing based on the constitutional principles about these Naxalite prisoners. These Naxalite prisoners don't owe allegiance to the constitution. They have rejected the constitution. So how can you ask us now to apply the constitution in their case? So Kannabiran immediately, see, that was something that was wonderful with him. His repartees were fantastic. He would talk from Shakespeare, he will talk from Byron, he will talk from Upanishad, he will talk from just about everything. He put it into a very simple way. He shot back at the court, telling the court, let me remind this court that what is at test is not the political principle of the Naxalites, but the constitutional principles of this court. So when we are coming here to say that the constitution has to be followed, what is at test is the constitution and the High Court.
This exchange distilled the essence of Kannabiran's practice. He saw lawyering as a way to reinvent the meaning of justice, freedom, liberty, and dignity. In the process, he made both the state and the Naxalites subject to the constitution. His approach earned him the respect of the bench. Kalpana explains.
He would go into a district court, like in the Coimbatore bomb blasts case. The judge just said, I have read your wages of impunity. So they were connecting emotionally with him through his constitutional arguments. So he was, what is the moral high ground you must occupy to be able to ask judges to put compassion above the status or their prerogatives under the law? The way he just held governments to account. Now, judges are watching all of that, whether or not they rule in favor of the petitioner and against the government is another matter, but they're watching what you are doing. And that is what contributes to the way in which they approach you as a person.
His stature also meant that he was called on to help find a political solution to the Naxalite conflict. From the 1980s, he was frequently invited by the government to negotiate with Naxalites. Despite the severe repression, the movement remained strong, and it carried out attacks on police officers and public infrastructure. In 1987, it kidnapped 7 IAS officers and held them hostage, demanding the release of Naxalite prisoners in exchange. The government asked Kannabiran to help free the officials. The poet Nikhileshwar reflects on that episode.
He negotiated the cases between the government and the Naxalites also, Saragopal himself, etc. I think we heard about that particular thing when some IAS officers were kidnapped by the Naxalites in East Godavari district, Mr. Shankaram and all those things. When these IAS officers, they were kidnapped by the Naxalites, then Mr. Haragopal and then Kannabiran, they went forward and negotiated for their release. So that one of the significant event in his life, wherein along with Mr. Professor Haragopal, he boldly went forward and they talked with the Naxalites and got them released.
Professor Haragopal is an academic, an activist, and a long-time colleague of Kannabiran. They convinced the government to keep police out of the negotiations, and they secured the safe release of the officers. From then on, Kannabiran was crucial to the effort to broker peace between the state and the rebels. He spent decades trying to create an environment for peace talks and for ending the violence. There were many false starts, and the dialogue finally fell apart in the 2000s. But Kalpana Kannabiran tells us that he was optimistic throughout.
There was never an opportunity that he passed up to try and see if something is possible in terms of a dialogic deliberation around a restoration of democracy, a restoration of constitutional system. He just tried every possible avenue that opened out before him.
Kannabiran participated in milestone moments in the human rights movement outside of Andhra Pradesh as well. He was president of the People's Union for Civil Liberties, or PUCL, for 25 years. Under his leadership, the organization joined a civil society-led inquiry into the 2002 Gujarat riots. Their report showed a clear collapse of law and order and sharply indicted the state government. He also passionately argued against the death penalty, and once even argued for the accused in the Parliament attack case of 2001. Throughout, Kannabiran opposed excessive state power and called on law enforcement agencies to follow the law themselves, as well as the principles of the Constitution. Kannabiran himself worked into his day-to-day practice and his activism a profound dedication to constitutional principles. He wasn't blind to the challenges surrounding him and his colleagues. He never rested on hard-fought victories, however small or large. Kalpana Kannabiran told us that her father sometimes expressed anguish over the work that lay ahead, but he was determined to carry on with it.
So one part of it is that he was not alone in the struggle. There were so many people, and he was pulling in those collective energies outside. The other part of it is he was not alone at home either. So there was always a spouse, children, dog, grandchildren. His house was never without a dog. His dog was his best friend, and so, and all of these kind of, helped him just, I wouldn't say unwind, it just helped him be the kind of person he was. He loved music of all kinds. He could sing all the old Telugu film songs. He could sing the old Hindi film songs.
Kannabiran made it his mission to free institutions like the police and the courts from colonial practices and legacies. In the process, he developed a jurisprudence of civil liberties which strengthened the idea of democratic citizenship laid down in the Constitution. He turned the courtroom into a site of vibrant dialogue on our constitutional ideals, all while defending the people, often branded by the government as the nation's enemies. In case after case, he urged the bench to see past this narrative and give their clients their due rights. His approach expanded the meaning and scope of our rights and freedoms as citizens of a democracy. His daughter Kalpana described this approach as insurgent constitutionalism.
So the only way to work the Constitution is to work it insurgently, because what you are doing in the course of bringing about a constitutional order is toppling the status quo. And that toppling of the status quo requires you to adopt a very different approach to constitutional interpretation. So that, words have meanings, of course, but meanings are not fixed, and meanings can be imaginatively crafted to tune with the spirit of a provision. And I think basically that was our approach to it.
In recent years, we've witnessed new state efforts to crack down on civil liberties activists and movements. For some, like the Telugu poet Varavara Rao, life has come a full circle. Rao was entrapped in some of the conspiracy cases that Kannabiran fought in the 1970s and 1980s, and he was implicated again in the Bhima Koregaon case in 2018. It's almost as if nothing has changed in the intervening years. This brings us back to Kannabiran's description of his work as Sisyphean. The fight for human rights may feel like a long road, but that makes it all the more important to keep going. Friend of the Court is an initiative of the Anil Diwan Foundation and the School of Legal and Socio-Political Studies at Ambedkar University, Delhi. Thank you to the guests on this episode: Kalpana Kannabiran, Nikhileshwar, D. Nagasaila, and V. Suresh. This episode was hosted by me, Raghu Karnad. It was researched and written by Ramya Boddupalli and Bhavya Dore. Malika Dandekar provided fact-checking and additional research. This episode was recorded at Stitch Audio, Mumbai, and produced by Gaurav Vaz. Sachi Rajadhyaksh worked on the sound design, and Ayan Day mixed and mastered it. Thank you to Sukada Tatke for editing support. Gauri Divan, Lawrence Liang, Ranveer Singh, Shyam Diwan, and Vivek Diwan advised the show. Special thanks to Justice Gautam Patel, Arun Thiruvengadam, Alok Prasanna Kumar, Deepa Dhanraj, and Reetika Subramanian.